In 1986, Australia declared full legal independence from Britain, or so we were told. But what if the law that claimed to sever the final tie was never valid? What if the people, the only lawful source of change, were never asked? This is not a story of conspiracy, it is a story of omission. And it begins, quietly, in silence. The Australia Act 1986 was passed by both the Commonwealth and the United Kingdom. Together, these laws cut the final British legal ties to Australia's states. It ended appeals to the Privy Council. It abolished the UK Parliament's role in state law. It redefined how state governors are appointed. But none of that, not one clause, was approved by a referendum. Under Section 128 of the Constitution, that's not optional, it's mandatory. To change the constitutional order, you must ask the people, and no one did. The UK version of the Act was signed on February 17, 1986, by Queen Elizabeth II, not in Canberra, not in London, but in Wellington, New Zealand, and not as Queen of Australia, but as Queen of the United Kingdom, acting on advice from foreign ministers. In Sue v. Hill, the High Court ruled that Britain is now a foreign power. So tell me, how does a foreign monarch, signing in a foreign nation, have the power to reshape the legal foundation of Australia? After the Act passed, every Australian state amended its constitution. Governors were no longer appointed on British advice. UK oversight was ended. New state powers were assumed. But those changes relied on the authority granted by the Australia Act. If that authority is invalid, then the changes may be invalid too. It's a domino stack, and the first tile was never properly placed. In 1974 and again in 1988, Australians voted on whether local councils should be recognised in the Constitution. Twice, they said no. Yet today, local governments fine us, rate us, regulate us. Their authority comes from post-1986 state legislation. But if that legislation was built on unlawful foundations, what happens to the structures built on top? We call ourselves sovereign. Yet our constitution is still a law passed by the UK Parliament in 1900. We use a coat of arms granted by King George V in 1912. We operate under royal prerogatives inherited from British common law. So if the Australia Act truly made us independent, why are we still carrying the Crown's paperwork? This isn't about nostalgia. It's not about breaking what works. It's about legal truth, about the right of a people to ratify their own sovereignty. Sir Harry Gibbs, former Chief Justice of the High Court, said, "There must be a real doubt whether the Australia Act is valid, unless it was passed in accordance with Section 128. That doubt has never been resolved. So we ask simply, if the people were never asked, can the law be called legitimate? There's only one way to know. Ask them now. Referendum, repatriation, respect for the rule of law. Because in the end, power doesn't come from silence. It comes from the people."